Welcome to the program. Lloyd Snook joins me. He, of course, is a veteran attorney here in Charlottesville. And Lloyd, you have joined the program today to help us understand some legal issues.
Let's try.
Things that are in the headlines in Charlottesville. And we're going to begin with a national story. And that is, of course, the Robert E. Lee statue. The city recently voted 3-2 to remove the statue to Robert E. Lee from a downtown park, Lee Park in Charlottesville, which was unveiled in 1924, about 60 years after the Civil War, as an homage to Robert E. Lee and the U.S. Confederacy, venerating the Confederacy and the life of Lee. The City Council has ruled that basically we don't think that Charlottesville should be honoring Lee in this public park, and we want they've put it up for sale and said somebody can take it away. Then came a legal move from those who want to keep the statue, and we just recently saw in the last few days, Judge Moore issued an injunction. What is an injunction, and what's going on in the courts?
Okay. First of all, I suppose I should provide a disclaimer that I really don't care about the issue. You know, I have plenty of friends who care passionately on both sides. I see both sides with some clarity. I've not taken a position on it one way or the other. But to explain an injunction is simply a court order for this purpose. The court order is, let's keep everything the way it is until I sort this all out. That's the judge saying, don't anybody go selling any statues. We've got to decide this issue first. Then maybe you can sell the statues, but not right now. And so what he did was he granted an injunction that says for the next 6 months, you can't sell, move, deface, whatever else, the statues, because I'm going to figure out the answer to this legal question. I may enter an order that allows you to move the statues. I may enter an order that says you can't. There will surely be an appeal after that.
Yeah.
But the point is, preserve the status quo. Don't change anything. Let me figure it out without everybody getting all excited.
Right. And the legal question at play here hinges on what exactly?
Well, the legal question is this. There are a couple of statutes in Virginia that say in artfully drawn language, let me put it that way, various things that are intended to say, don't go messing with our statues about wars. And it's not just the Civil War statute. In fact, the statute, the law provides that you can't move monuments or memorials for any war or conflict or for any engagement of such war or conflict, to include the Algonquin War in 1622, the French and Indian Wars in 1754, the Revolution, the War of 1812, the Mexican so on, and of course,
cover them all.
Cover them all, including Desert Storm and the global war on terrorism and Operation Enduring Freedom. The point is that the statute says don't go moving memorials that are memorials for any war or conflict or for any engagement of such war or conflict. A statue of Robert E. Lee is not, on its face, a memorial to a war. It's a memorial, you might say, oh, come on, it's about the war, but it's not a memorial to the war. Now, there's a second statute that is the very next provision in the code that uses slightly different language. It talks about a monument, marker, or memorial for war veterans. So what does that mean, for war veterans? My father served in World War II. His name is emblazoned on a plaque on the Drury-Brown Bridge. Does that mean that they can never move my father's name off of the Drury-Brown Bridge?
Because he's a veteran.
Because he's a veteran.
Right.
He's a veteran of a war. If you're going to be absolutely literal about the statute, that's what that would reflect. Now, a more logical way to look at it and say, let's look at the two together. What we're really talking about is, if there's a memorial to the war or to the war veterans, don't go moving it. War veterans is different from war veteran.
Right.
It is not true that every single person who ever served in a war is protected by this statute. And there is a recent Attorney General's opinion that lends a little bit of clarity to that, in the sense that the issue that was presented was there was a memorial to a building that had been used during the Civil War down in Danville. and they wanted to know if they could move the memorial to the building. And the Attorney General said a memorial to a building is not a memorial to a war, even if the building was used in the war. By the same token, a memorial to Robert E. Lee isn't by itself, so the argument would go, a memorial to the war. It's a memorial to one guy who happened to serve in the war, happened to be a general in the war, but it's not the same thing as a memorial to the war or as a memorial for war veterans. So the issue that Judge Moore is going to have to try to sort out, and just by articulating this and sort of seeing how technical the language is, when I've explained this to other people say, oh, come on, come on. The law can't be that
This is what
stupid.
lawyers get paid to figure
That's
out,
right.
though.
And the real problem, if you can fuss about lawyers, you ought to be fussing about the legislators
Who wrote this
the bill.
law.
Why did they use different language in section 1812 and in 1812.1? Why not use the same language in both places?
Because it's the same law, but very clearly in different parts of the law it says different things.
Right, 1812.1 was added in 2000 in response to something in particular, whereas this other code, the other thing has been in law since at least 1962. They were clearly written by different people at different times. But when legislators go down to Richmond, one of the hazards of doing things in a short 45-day session and people going boom, 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 is that sometimes people don't have a chance to sit there and think deep thoughts about how this connects to everything else, and so we get language in here that's confusing.
Right, and this is what the Judge Moore, is going to have in the circuit court, right? In Charlottesville. This is what he's going to have to try to figure out so that the city knows what the heck it can do and not do with this statute.
Well, yeah, and in fact, it's then whichever side loses is going to appeal to the Virginia Supreme Court, because in Virginia, Virginia is crawling with monuments to somebody who fought in a war sometime.
Right.
And somebody needs to tell us what this thing actually means, and whether the one language or the other language applies. So when an injunction is granted, there are two issues that come up. The first issue is there a likelihood that the folks asking for the injunction will win? The second is, will there be irreparable harm to either side, either if I grant the injunction or I don't grant the injunction? So in this case, the judge made comments, I interpreted his comments that I saw as being less directed towards I am sure that the protesters are going to win, and more to the point of, what's the harm in just leaving things as they are for another 6 months? That there's no irreparable harm that would come from leaving things as they are for 6 months. Give us a chance to sort it out.
And in his injunction, in his ruling, he drew specific attention to this law and said, we got to figure out this law. There's a state law that is pretty clear about something to do with not moving statues and memorials. And that's the nut that needs to be cracked there, and we need clarity on it. And as you say, no matter how he rules, this is going to be appealed to the Supreme Court. And
just to highlight some of the ways that it could get really kind of picky about things, there are actually 3 statues in this that deal with the Civil War downtown: Lee, Jackson, and the Confederate statue.
It's called At the Ready.
At the Ready.
1909, and it shows an anonymous Confederate soldier with his gun ready to go into battle.
Right. That one seems clear to me to be a memorial to a veteran of a war, to the veterans of the war.
Right.
That's right. The Lee statue is a little bit more of a statue about the war, because they've got emblazoned around it all of the battles that were fought and so on. The Jackson statue, aside from the fact that he's wearing a uniform, there's nothing about that that cries out, hey, this is all about the war. So if the judge wanted to, he could draw on all of these different things and to compare them. If you wanted to continue with the question of, well, how about other statues that would be covered? The statue of George Rogers Clark down by the university would be covered under this. Could the university decide at some point, that's a really prime piece of real estate, we've got other uses for it, can we move that statue?
Yeah. And there's also another Confederate memorial in the cemetery at UVA.
That's true.
And that is, by definition, that is an anonymous memorial to veterans, plural, who perished in the war and were buried in that cemetery.
Yeah.
So, yeah, clearly this is something you need to figure out. And Charlottesville and Virginia aren't the only communities in America that are grappling with this right now. This is an issue all across the South.
New Orleans is having a terrible time figuring that out.
They got protests in the streets.
That's right, and they had people getting shot around the protest. They wound up taking out one of the statues at 4 in the morning in the hope that nobody would notice what they were doing. You know.
So, what are the options for the sides here, and to what extent, Lloyd, those who say, you know, the city's got better things to do, and we're going to spend all this money fighting this court case when all they got to do is leave it alone. It's been there since '24. A lot of people are saying that this is a waste of resources.
Well, and there are a couple of answers. The first answer I would say is that if we thought there was any chance that the General Assembly could clarify things for us, that would be the easiest way to do it.
Right.
That if the General Assembly were to sit there and say, okay, people, let's come to a compromise on this. Let's amend all 3 of these statutes that have some relevance here, and let's get them all consistent using the same language and explaining our terms. One of the things that the Attorney General said in one of his in the opinion that I was mentioning, is he notes, he said, the terms war, conflict, and war veterans are not statutorily defined. Now, I'm sure that when somebody was writing the bill, they said, what do you mean, we got to define war? Well, actually, you do under federal constitutional precedent, but that's another story. We have to define what conflict means? Come on. But this is the situation we get into if you don't.
Yeah, and the intent, we sort of know what the intent of these statutes were aimed at, right? They were aimed by a majority Republican legislature in Virginia. They were aimed at keeping Confederate monuments and memorials in place in these public spaces.
And certainly the first statute in 1962, just as the centennial was going, I'm sure, and the centennial was going, meanwhile civil rights stuff is going on in Danville and every place else, I am sure that the statute that was enacted in 1962 was very specifically about Civil War things, and they didn't want anybody tampering with Civil War monuments. They added all this other language about these other wars later on. The statute got amended a number of times, 82, 88, 97, and they keep adding things to make it abundantly clear now that we don't care what war it is. If somebody was wearing a uniform on behalf of the government, leave it alone.
Yeah.
But you know, one of the problems we've got here is if you could never move anything like that, at some point we're going to get completely swamped in monuments.
Right.
You know, life goes on.
And how do you explain this to somebody who's watching from outside the area? That, you know, in Charlottesville, you can't necessarily do what you want to do in your own community. You have to follow the lead of Richmond.
Well, when the city gets sued, it's always obviously expensive to defend, even if it's just in terms of time. In this particular case, I think that the city's insurance company has said, we're not going to try to defend this, we'll let you guys defend it. So it's something that's got to get defended, but it's also an issue that has to get decided. And the fact that it's going to be expensive for Virginia, as well as for the city. Yeah. And just as an example, you know, if we get into this question of can you ever move any monument to anybody who ever served in a war, as a state, that's going to be an untenable situation. We've got to get that figured out. So yes, it's going to be expensive. It's going to be a hassle, but it's something we've got to do.
Yeah, so this, you know, here we are in May. We've got a 6-month injunction, which takes us into the fall. What's the timeline after that? Is Judge Moore going to come back in the fall with a decision, or is he going to punt this in some way? What's the timeline? What can we expect?
First, there will be some initial set of discovery procedures. This is not one where the facts are very much in dispute, but there's some things that people have to decide whether they're willing to fight about them. For example, are we truly fighting about the character of the Lee Monument because it's got the names of the battles around it? There's some decisions like that that both sides need to make about what they're truly fighting about. There will be some motions, and there may be a brief hearing with some evidence presented, but mainly oral argument. The judge will have to decide. He's given himself this 6-month window. I think we can reasonably anticipate that we'll have a decision from him within 6 months.
Okay. And then to the Virginia Supreme
then to the
Court.
Virginia Supreme Court, regardless of whoever wins.
Could we expect next January to see the General Assembly explore this with legislation and try to clean it up?
They could. The problem is that they've got to get first of all, it's going to depend on who the governor is.
Right.
Second, it's going to depend on who is actually willing to stand up in the legislature and sort of defend the Civil War. That 10 years ago might have been an easier defense to make. Right now, in the current political climate, there are going to be a lot of Republicans who are going to be very uncomfortable trying to stand up for this kind of position.
Yeah. Let's take a quick break. When we get back, another big headline here in Charlottesville, and we'll go behind the scenes with Charlottesville attorney Lloyd Snook. Stay with me. We'll be right back. Welcome back. We're talking with Lloyd Snook, Charlottesville attorney. Lloyd, big story here in Charlottesville, and it has been for many, many years, is the fact that we have two local governments here, a city and a county. The city of Charlottesville, the county of Albemarle. They both have their courthouses in downtown Charlottesville, and the county has been expressing interest for a long time in taking those courthouses out of downtown Charlottesville and putting them out in the county somewhere as an economic development initiative. And this has been a real source of contention between the city and the county for a long time. What's the very latest?
Well, to set the stage, it's important because it's important that people recognize how truly unique Virginia is. We are the only state in the nation where a city is not a part of the county that surrounds it. So Charlottesville, in 49 other states, Charlottesville would be part of the county of Albemarle. Not true in Virginia. And so you've got the situation where if a building is located, as the county courthouse arguably is located in the city of Charlottesville, within the boundaries of the city of Charlottesville, the county may own it, but it's subject to city political and legal jurisdiction. And the issue that we're going to end up fighting about is, well, actually going back in history at least to 1888 and maybe something since that time, is the county courthouse part of the county, or is the county courthouse part of the city? The issue right now is this. There is a statute in Virginia that has been on the books for many years that says if any political subdivision, any city or county wants to move from its courthouse from where it is now to anything other than an immediately adjoining parcel of land, it's got to get a referendum of the voters in that city or county. So if
because they're the ones that are going to pay for the move.
They're going to pay for the move.
Right.
So if the city of Charlottesville decided they wanted to move the circuit courthouse from the corner of 4th and High Street down to, let's say the Lane Office Building. If they had, let's say we buy the Lane Office Building back from the county, we decide we want to move the courts down there, we have to have a referendum. Over in Stanton last year, they wanted to move the Augusta County courthouse from downtown Stanton out to Verona. And the voters, by a 2-to-1 vote, said, no, we don't want you to do that. It's expensive, it's not traditional, etc. So right now, where at least some members of the County Board of Supervisors have been pushing to move the county courts out of downtown and out to some part of the county, I say we, certainly in the legal community, because the legal community, the law enforcement community, everybody who uses the courts is saying, no, don't do that.
Don't move them.
Don't move them. Leave them as they are.
You have a whole infrastructure of the justice system in place that doesn't want the courthouses moved.
Every user of the courthouse is saying, don't do this.
But you got a handful of politicians in the county, elected leaders, who are like, well, maybe we should.
Well, and their reason has nothing to do, and they will freely admit, has nothing to do with the efficiency of the court system. It has to do entirely with this question of economic development, and would it be an engine for more growth in some other part where we get more tax revenues, whatever. And what they've talked about is moving the courthouse either out someplace on 29 North. Apparently there's some land that has been talked about as being donated that would be beyond Walmart and so on.
Right.
There was also at one point a proposal to put it on Albemarle Square, which has been not doing terribly well financially. And of course, those of us who look at it and say, you really want me to have to go out 29 North to get to court when it's such a hassle just to venture out there at all?
Yeah.
So anyway, so that's the issue, is this statute that says, county, if you want to move from downtown Charlottesville elsewhere, you're going to have to get the voters to say yes.
Legally required.
Legally required.
Referendum,
right
voters decide.
Right. Effective July 1, because of this legislative session, there is a new statute that says it's not exactly true, and they say, in the case of the removal of a county courthouse that is not located in a city or town and is not being relocated to a city or town, the removal would not require petition or approval by the voters. So, if we can determine that the county courthouse really isn't in the city, it's surrounded by the city, but because of some quirk in the grant in 1888, it's still technically county. If that's the case, then we could move it out to 29 North in the county without having to ask the voters.
Because it's not really in the city, the argument would go.
Right.
It's that little postage stamp of land is owned by the county.
Right. And about 15 or 20 years ago, there was a case that came up where the circuit court judge really wanted to be able to prosecute somebody in the county courts for having lied in the county court. That would only work if the county court is located in the county. If the county court is located in the city, it would have to be prosecuted in the city court.
Right.
And so an opinion was rendered that said, I believe that the county courthouse is actually in the county, and that in 1888, when this 4-block by 5-block area was designated as the city of Charlottesville, we didn't really mean this corner.
Now, so there is a legal precedent then?
There is an opinion out there that says that. There is also a case kind of percolating through the system where that issue is getting revisited. I think it's a criminal case of some sort. And so it's not clear under this statute, under this change that has been made, it's not clear whether that truly does apply to the city of Charlottesville and county of Albemarle. It might. I don't know the facts. I don't know the 1888 history well enough. But that's going to be where that issue gets decided.
And this is a question that obviously will go to courts, because I can think of a few attorneys in town who would like to bring a suit against the county for trying to move these courthouses.
Well, sure. And all of us who use the courts, we rely on the fact that, let's say we tell a client to go to district court or to go to the circuit court, and they go to the wrong circuit court. Well, now it's a 2-minute walk.
They can just walk across the street and go to the right court.
Go to the correct court. Or the bailiff can say, you're in the wrong court, go over here.
Happens all the time.
Happens all the time. Happens
to
lawyers all the time.
Now they would have to go back to the parking garage, get in their car, and fight traffic.
And it's a half hour.
Get up 29, at least a half hour.
Right.
Yeah.
And so there are a lot of reasons for the efficiency of the system, why it's important to those of us who use the system that all the courts be as compactly located as possible. But I also recognize that that's a political hot-button issue for some folks in the County Board of Supervisors.
Yeah, so what's the next step in that conversation?
Well, the next step in the conversation, now that this statute has been brought to everybody's attention just this week, the next step in the conversation is probably going to be if the county says, we're going to move it, we're going to move the courts, then somebody's going to file a lawsuit for declaratory judgment and so on.
And we'll see an injunction on that issue.
And I'm sure we will. But I would hope that what we would actually get to is a situation where we can base the decision on what's good for the courts and figure that ultimately the economic development piece will take care of itself. The fact is that there has never been a reliable study showing that locating a court someplace out in the boonies helps economic development for the boonies. In fact,
which is a huge important part of this that the county should be looking at.
Yeah, and you can look at just an example, Williamsburg and James City
I was
County.
just thinking of the exact same thing. Out at Newtown.
They plunked this big, beautiful, grand courthouse out in the middle of nowhere.
Yeah.
And then they're sort of waiting for something to develop around it. At least so far it hasn't happened.
Yeah. And that's what they need to look at here. Look at the facts of the issue. Yeah, Lloyd, thank you for being here. Lloyd Snook, Charlottesville attorney, and going behind the headlines of some of the big issues here in Charlottesville, Virginia. I'm Coy Barefoot. Check out the complete archive of this program. All of the interviews are online at mediaandcitizenship.org. Have a terrific week, and y'all be good to each other.